My name is Richard Jolly. I'm a professor at Southwestern Law School and a fellow for the Civil Justice Research Initiative. I'm really excited to be moderating this first panel on this important issue. But before, I want to add one more thanks to everybody, particularly the Berkeley Judicial Institute, which was instrumental in organizing today's event and making this important discussion possible. Now, this first panel is going to really focus on the emergence and prevalence of attacks on the court. And for this discussion, we have a tremendous group of panelists. Alicia Bannon will be speaking about the prevalence of the attacks. She is the managing director of the democracy program at the Brennan Center for Justice at NYU, where her work focuses on promoting a fair judicial system and an inclusive democracy. She's an experienced constitutional lawyer and an expert on court reform, access to justice in the legal system, electoral redistricting, and fair representation in government. Denyse Clancy will be speaking next about the attacks that are not just on our courts, but on our lawyers, how broad these attacks really are. Denyse is a partner in the Oakland, California law firm of Kazan, McClain, Satterley, and Greenwood. She's a nationally recognized appellate and trial lawyer with prominent experience in asbestos and talc litigation and other toxic torts. We will then have James Brosnahan, who will be contextualizing this discussion, both within history and how they've affected courts and practitioners. James is a partner at Morrison & Foerster and a lecturer at Berkeley Law School. He has over 50 years of experience and has tried to conclusion over 150 cases. He's widely regarded as a lion of the trial bar and one of the most respected and recognized trial lawyers in the United States. And finally, we have Dean Erwin Chemerinsky. He'll be speaking about the First Amendment considerations raised by these attacks. Erwin is the Dean and Jesse A. Choper Distinguished Professor of Law at Berkeley Law School, as well as the President of the Association of American Law Schools. He is, of course, a prolific scholar, authoring over 200 law review articles, and an active advocate, regularly arguing appellate cases, regarded as a titan in the legal academy. Now, the way this panel will be run is I'm going to give each of our panelists roughly 10 minutes to speak, which will hopefully leave us time at the end to address questions from the audience. So I hope you've brought them, and I hope our discussion, I'm sure it will prompt your thinking. So with that, Alicia, perhaps you could kick us off by bringing home really the prevalence of these attacks.
Thank you so much for that introduction, and thank you to the other panelists and everybody joining us today. It's a real pleasure to be part of this important conversation. So in terms of the prevalence, I mean, there's a broad set of things that you might think about as encompassing attacks on the judiciary, everything from so-called judges, efforts to delegitimize individual judges or the decisions that they make, to, of course, sort of physical violence. And there have been, some horrifying incidents in recent years of, touching on the physical safety of judges. I'm going to be speaking about one dimension, one piece of a much larger conversation that I hope we'll be covering today, which is specifically looking at state courts and about a particular trend that we've been documenting at the Brennan Center for Justice, where we've been seeing basically assaults on judicial independence in state courts, particularly coming from state legislatures as well as from governors. To start us off, why state courts? Most of the time, and I'm speaking at a law school, and a lot of the time and attention when people are learning about the courts, focusing on the courts, is really focused on the federal courts. And frankly, state courts don't get the same stature or attention, either at law schools or among the public at large. But the fact is 95% of all cases are filed in state court. They're tremendously important. State Supreme Courts are the final word typically at least the final word in interpreting state law, state constitutions. And, I'll say in, the particular moment, as we have a Supreme Court that has been increasingly foreclosing certain kinds of remedies, state courts are only becoming more important. Just this week, the Ohio Supreme Court struck down both the congressional and legislative maps that had been drawn in the state as violating their state constitution. After, a few years prior, the US Supreme Court had foreclosed federal constitutional challenges to partisan gerrymandering. So, we went to the state courts, and the state in Ohio, the state court stepped up and said that it violated the state constitution. So in a host of areas, not just redistricting, voting rights, criminal justice issues, environmental justice, reproductive rights, state courts are increasingly becoming a real focal point, and that has brought attention, not necessarily public attention, but certainly attention from the political branches of government. And as I said, at the Brennan Center, we've been tracking various efforts by legislatures and governors that are targeting the court. And we've seen, as I said, a troubling trend, often in response to unpopular decisions, especially decisions that are in tension with the with the goals of a particular sitting governor or state legislature, sometimes focused on getting more political control over the judiciary or weakening the court's authority. To give a couple of recent examples, in North Carolina, after Democratic governor won in that state, in the window between when he won and was about to take office, there was an ultimately unsuccessful push to pack the North Carolina Supreme Court to get more seats to shift that court in a conservative direction. The legislature successfully changed the size of the intermediate appellate court, again, to take appointment opportunities away from the governor. They tried, there's an unsuccessful effort to gerrymander judicial districts to cut the length of judges' terms. They successfully moved the state from nonpartisan elections to partisan elections, all very much and largely explicitly to target that court out of a concern that the court had grown too liberal and that the legislature wanted to have more control over it. And just recently, we've seen calls coming from leaders in that state for the impeachment of certain judges, again, for unpopular rulings or the threat of certain unpopular rulings. In Alaska, you had the governor a few years ago vetoed $300,000 from the state's court budget, explicitly in response to a ruling by the state Supreme Court there that had blocked restrictions on Medicaid funding for abortion. Ultimately, there was litigation brought by the ACLU of Alaska that struck down that line item veto on judicial independence grounds, but it had been vetoed by the governor. And in Kansas, there was a move, again, a few years ago to take away the court's, to limit the court's budgetary and administrative authority, and pretty much explicitly in response to a series of unpopular judicial decisions, largely around education and requiring the legislature to increase funding for public education and enforcing various state constitutional provisions. There, the Brennan Center actually represented some state judges challenging a law that had weakened the court's administrative authority. In response to our lawsuit, the legislature actually sought to defund the entire judiciary. They created a non-severability provision between the item that we were challenging and the entire budget for the judiciary of Kansas. There, I think arguably they went a bit too far because there was sort of such public outrage in response to that. It was such an overt attack on judicial independence that eventually the legislature pushed back and they reversed themselves and took out that non-severability provision. But that was the environment in Kansas. And so in 2021, this past year, we saw in many ways a continuation of some of the trends that we had seen, but also in some dimensions a troubling escalation. And the piece that I would lift up in particular is a targeting of courts specifically for their role in election cases, and often explicitly in response to judicial decisions that had come out in the context of the 2020 election. Now, sort of some overall figures, in 2021, more than a third of state legislatures considered bills that would have limited the court's power or otherwise sought to gain more political control over the courts. Of the 153 bills that were introduced, 19 became law across 14 states. Now, specifically looking at bills that were targeting election provisions or the court's role in elections, first off, again, as background, I probably don't need to tell folks on this webinar that state courts played a really central role in a lot of dimensions in the 2020 election. That included protecting voters during the pandemic, as well as rejecting partisan efforts to manipulate or overturn election results. And this has, in many states, put those courts in the crosshairs. In at least 10 states, legislatures introduced bills that would have either weakened courts' powers in election-related cases specifically, created new tribunals to hear those cases, or targeted individual judges for their decisions in those cases. In other words, efforts at impeachment or removal of judges in response to election-related decisions. We saw 4 bills pass in in Georgia. A new law makes it more difficult for certain judges to extend polling place hours because of long lines, power outages, and many of the other issues that come up on election day. And in 3 states, Kansas, Kentucky, and Texas, new laws prohibit judges from altering or suspending state election laws. In addition to these laws that are sort of specifically targeting election cases, there were a number of others that were passed that sort of went more broadly to either courts' power or how judges were selected in the states. We saw 19 states overall considered bills along those lines, and we saw 8 bills passed in 6 states that were these more general bills. To give just a couple of examples, in Montana, we saw the elimination of the role of independent judicial nominating commissions. So in other words, in how the system used to work in Montana was that when vacancies emerged and the governor was supposed to make appointments, there was initial vetting by a nominating commission in an effort to create some independence between the application process and the governor. And this law removed the role of the nominating commissions and now gives the governor the power to directly make those appointments. We also saw bills passed in Kentucky and Tennessee, which change which judges or which courts get to hear certain kinds of cases, specifically cases involving litigation against the state. So essentially some forum shopping to make, to funnel cases away from certain courts and towards others. I know there's a lot of panelists and a rich discussion, so I want to make sure I leave time for others to weigh in here. I'll just end kind of where I started, saying, that these state courts are critically important, and they often don't get the attention that is warranted. And we're early in 2022. Many state legislatures have just started their terms, but we're already seeing some of these trends continue. So, for example, in Pennsylvania, we're hearing word from folks on the ground in that state that the legislature may be taking up a constitutional amendment that's already passed once. The process is it needs to pass twice and go on the ballot. That would take the state Supreme Court, which is currently elected statewide, create districts and give the legislature unfettered power to draw those districts. So essentially to allow for gerrymandering of that state Supreme Court. And these issues are serious. They're ongoing. And I think there's a real urgent need to pay attention. As I said, state courts are, I think, increasingly going to be playing a critical role in a whole host of areas in protecting rights and hearing cases of great public importance. And yet, in a lot of dimensions, they lack the same kind of institutional independence that the federal judiciary enjoys. And I think we're long overdue to kind of give those courts more attention and to sort of mobilize the legal community as well as the broader community to ensure that judicial independence norms are respected and enforced in those courts. Thank you.
Alicia, thank you so much for that fantastic review of just really how widespread this issue is and how, when presented together as you've done, how terrifying this might be when we think about the integrity and the independence of our courts around the country, not to mention the motivations that underlie some of these attacks. Denyse Clancy is going to speak next on really how these attacks on the legitimacy of our judiciary aren't tied just to judges, but rather the system and the attorneys that operate within them. Thank you, Denyse.
Thanks, Richard. I'm going to go ahead and share screen. One sec. Okay. All right, everyone should be able to see the screen hopefully now. Okay, so I'm talking today about attacks on the judiciary and more specifically and on counsel. And what I'd like to really convey, hopefully through my talk, is that attacks on counsel are attacks on our judiciary and our attacks on the system as a whole, our very fragile system. So I'm normally a person who, when I give a talk, I say, okay, look, I'm going to give you a talk and I'm going to tell you, we can do it. Like, here's my solution. Just follow the rules, file a motion in limine, file trial briefs. Here's how you fix this whole problem. Yet yesterday and in the weeks preceding this talk, as I was pulling materials together, I became increasingly despondent that I actually don't have the answer, that this is a problem that I have tried repeatedly to solve sort of by myself and with other counsel working with me. And we have not yet been successful in solving it. And let me show you what sort of the depressing things that I unearthed in going through this and preparing this presentation, and sort of the journey that I've taken on this path. So when I started out, I come from a family of attorneys, and it was very taboo when I started out after law school to attack counsel. In fact, I was taught you don't even call opposing counsel by their name, that they're the company, they're their client. You don't ever impugn them or do ad hominem attacks. And so this new trend has been very surprising for me and actually hard to deal with. It's not hard to find rules that you don't attack opposing counsel. I'm going to go through these very briefly. I mean, that our adversarial system itself relies on attorneys to treat each other with a high degree of civility and respect. You don't have to look very far. Section 1 of the guidelines of civility and professionalism state that you have to have dignity, decorum, and courtesy, that they're essential to promote justice. And indeed, personal attacks on the character or motives of the adverse party are by definition misconduct. So it's not, but the problem that I found is that, well, okay, sure, I can recite the law, I can recite all the rules, but I found that just knowing and reciting these rules, where does that get me? It's gotten us really nowhere so far. And here's sort of the history that I want to show you. So starting on in 2018, this is a case, a closing argument that's fairly infamous because the attorney who gave it later talked in the press about how proud she was about this closing argument and how it, won the case for her. And so if you can see the screen, she says that it's plaintiff's attorneys, I'm looking at the upper left-hand side, that get you to believe any kind of case. And she says, because we're here in New Jersey, particularly in central New Jersey, we're a pretty skeptical bunch. And you can move down and says, we've got the boardwalk games where the games are always kind of rigged against you. We've got psychics, the fortune tellers, the flim flam man, the 3-card Monty, the flea market vendors who try to convince us that the knockoff goods are really real. We've seen telephone scams, credit card scams, insurance frauds. We've seen it all. And the plaintiffs, they ran out of people to sue. The money machine, the plaintiffs' lawyers, and their highly paid $30 million expert, they ran out of people to sue. So she's making quite a direct comparison between the attorneys themselves and I guess sham artists in no uncertain terms. They said, and she said, and I want you to pay attention to this phrase because this is a phrase you'll see a lot. They'll say anything for money, 1-800 call, we'll sue. This is her closing argument. This is why she said the plaintiffs brought the case. Just call them, we'll make up a story, we'll get money. And she won. They won the case, and remarkably, then told the press after the case that she decided after doing this, after looking at the talc litigation, that the way to win would be to really hammer hard on that this entire litigation was a sham, quote, a sham concocted by plaintiffs' attorneys. So let's think about what that means. So when you say something is driven by attorneys or concocted by attorneys, in what you're really saying is they lied. They manufactured evidence. They came up with falsehoods. They somehow got it through summary judgment. They tricked the court. They got past the motion for non-suit at the middle of trial, and they fooled us all, which is an incredible attack on the integrity of the attorneys. And here she says it worked. So I thought, okay, let's file a motion in limine. Tell the court this is happening. this is violative of the rules. Let's try to fix it by educating the courts. So in 2019, this was a talc case in which I tried with Mr. Satterley, my co-counsel. And what happened in this closing argument, after we'd filed a motion in limine asking them not to attack opposing counsel, they literally said, what a tangled web we have right here. We have Mr. Satterley and Ms. Clancy. And they put the plaintiff's lawyers in the middle of, quote, plaintiff's tangled web, where they claimed that we, Mr. Satterley and myself, had manufactured all of the evidence. And everyone knows the quote, what a tangled web we weave when we practice to deceive. So that was directly referencing and stating that we, the plaintiff's lawyers, were at the center of a web of deception. In 2020, I then handled an appeal where they accused the trial court of letting in all of this deceitful evidence, and said in the very introduction of the appeal that the plaintiffs have been trolling for those suffering from mesothelioma. If you have the disease and if you have ever used cosmetic talc, please call our 1-800 number, they say. This is, and I can promise you, there was no evidence at trial that we even advertised, because we don't, or that we said call the 1-800 number, but that was what they put at the forefront of the appeal. Again, this keeps going in 2020. Here's another closing argument in New Jersey, where they say that the plaintiff's attorneys, they found their money train. Because they can get juries to believe there's asbestos in baby powder, the money train goes on for a long time. Why all of a sudden, after 125 years, your baby powder has been on the market? Why all of a sudden, why are they bringing lawsuits? It's because of the money train. That's why they're creating, quote, the lawsuit story. So obviously my motions in limine haven't worked. Obviously educating the court hasn't worked. The court in this case in 2020 in New Jersey says at the end of this closing argument, you have now violated a court order against attacking opposing counsel. You have violated so frequently in your closing argument that I can't sift the wheat from the chaff. It's impossible for me to say, okay, this line that you said is permissible, this line that you said is impermissible. And so the court in that case ended up striking the closing argument. And then that led to an appeal. The appellant J&J does not violate doesn't contest that there had been a violation of a court order, that their attorney blatantly violated the court order in closing. But nonetheless, they argue that the court should have adhered to a lesser remedy than striking the closing. They say that that it was a violation of their constitutional right for their closing to have been struck, despite the fact that they violated a court order not to attack opposing counsel. But here's the problem. When you are a plaintiff or a prosecutor in a criminal case, and the other side violates a court order, such as attacking the integrity of the profession, when you're a plaintiff and you have a dying plaintiff, the last thing that you could have is a mistrial based on misconduct, right? That is going to irreparably harm your plaintiff. So, or this could be solved on appeal after you lose, but that's an equally untenable situation. Or the court could have issued a judgment and struck all the pleadings of the defendant, but that would be seen as even more draconian. So there was no lesser remedy than striking the closing. Yet, nonetheless, on appeal, we're now battling the issue of another significant error was the striking, this is what defendant claims, of J&J's entire closing argument in the liability phase, allegedly due to improper commentary. We have found no New Jersey decision in which a court has taken such extreme action. So the trial court, we had an issue where we brought a motion in limine. We asked for there to be no attacks on counsel. There were attacks on counsel. The trial court weighed all the options. The trial court struck the closing after there had been repeat attacks on counsel. And yet this is now a major issue on appeal because of the struggle that the trial courts have to grasp for the appropriate remedy when there are attacks on opposing counsel. And so you think, okay, maybe that was the end of it. But no, in 2021, this is Johnson & Johnson's petition for bankruptcy. This is their informational brief, the brief that they filed with the bankruptcy court and letting the bankruptcy court know purportedly what is going on here. And what do they say it's going on? They say it's against the backdrop of the declining asbestos industry that J&J and JJCI have emerged as new prime litigation targets. Suddenly, a new white powder, not unlike asbestos itself for storytelling purposes, and hope for yet another wave of the never-ending tort materialized. So again, even in the bankruptcy filing, even in a situation where J&J is coming to the court and seeking equity, they say the entire fault lies with the nefarious plaintiffs' attorneys who have tried to create a new wave of asbestos tort litigation based on a fraudulent story. So after going through this example and how I've been apparently completely ineffective since 2018 at stopping any attacks on opposing counsel, despite knowing that this is a problem and despite trying everything to stop them, I was thinking, well, what sort of would describe my feelings about this? And the one that came to me was Macbeth's statement when he says, this is just, life is just, have we come to the point where life is just a tale told by an idiot, full of sound and fury, signifying nothing? And I think that's resonant for two reasons. One, it shows how depressed I am about the state of affairs, but two, the reason that Macbeth says this and it gives Macbeth power is that if entire story that we're living in is meaningless, then all of Macbeth's nefarious actions, they're not harmful. They can be justified because there is no overall construct which would damn them as good or bad. And I think that's resonant here because if we so disrupt our court system and our system of justice that it becomes just infinite ad hominem attacks, then you dismantle the very system itself. Why does this matter? One, it matters for two reasons. If defendants such as this TALC defendant keep doing this, that must show that they have real feedback from real people that it works, that attacking opposing counsel personally is a very effective thing. And two, it shows that they have no impunity, that I showed you a series of things that it just keeps escalating from on and on and on, despite all of our efforts to educate and the court as we're in it. And they have not obviously felt that they've suffered any repercussions. That shows that the system in terms of punishing ad hominem attacks is fairly broken. The other reason it really matters is that belittling is powerful. I don't mean to make this, overly aggrandize this, but when you attack people personally, you attack the very fragile agreement that we've had that we're all going to come together civilly to solve these problems based on the facts. This is a very fragile compromise, a very fragile social construct. And by belittling people and making it about the person and not about the facts, you destroy the social construct itself. And if you think about, again, I'm not going to, but the way that wartime atrocities occur is by dehumanizing the other. The way that we are no longer practicing in a civil system is by dehumanizing opposing counsel, and it must stop. But then I think, what is the story that we all learn that, Horton hears a who? In that story, we learned that the littlest voice matters. It was only till the smallest who in Whoville stood up and spoke out that everybody could hear and know that they had to be respected. And that's resonant to me for two reasons. One, it teaches us that no opposing counsel is little. No one should be attacked in the courts. But two, I want to tell you what is giving me hope now, what is giving me hope is all of the people on this seminar and all these brilliant minds that I'm together with today, who I know can figure out a way to publicize this, to restore integrity to our court system, and to think of ways to empower our judiciary, that we go back to a time when this is no longer okay. It's not considered acceptable advocacy to attack your opponent personally. And so it is to you that I say, thank you so much for joining, and thank you so much for helping to put our minds together to create a solution.
Denyse, thank you so much for providing that fantastic overview and really tying it to your specific experiences and showing how the lack of civility is affecting our judiciary overall. James, perhaps you could speak next on contextualizing this for us, helping us understand both historically and in this moment what this lack of civility and attacks on our courts is looking like.
Well, I'm happy to try to do that. I'm excited about the presence of over 300 people who came to listen to us talk. And the takeaway from both these panels is very simple. This is Friday afternoon. I hope you're going to relax. Monday morning, you're going to call somebody. You're going to write a letter. This is intolerable. Why is it intolerable? The separation of powers took, depending on when John Locke was born in the 1600s, took about 200 years to create. The first people who suggested it in writing, some of them didn't publish it until they were dead because kings sat. And when this country was formed, there were 3 departments. And of course, it goes without saying, we're talking about the judiciary. And the rule of law is all about the judiciary. And when they are threatened, as they are now, and when the lawyers are threatened, as they are now, that rule of law is undermined. And we have enjoyed a period of time, I think, in our lifetimes, when we haven't had to face that kind of thing. For example, an FBI reports that in 2015, there were 926 threats and other inappropriate conduct against federal judges. By 2019, there were 4,449 complaints. Who's going to protect those judges? That's what this program is all about. Who's going to protect them against the domestic extremists that the FBI also described? Racial and ethnic beliefs, often advocating for the superiority of the whites. Those are real people. They carry guns. They're organized. That's what we're talking about here. It is, we don't want to face, I don't want to face it. I don't want to face it. I've enjoyed going into courts for a long time. I don't want to face it. And then there are all the people who are mentally ill, who come to the courts, in part because they have to be helped in some way, in part because they have some case and they have difficulty in understanding the difference between peaceful presentations. I wrote 2 articles in 2020 on the defense of the judges. And as often happens when I write an article, nothing happened. I focused on 2 situations. One was the then president of the United States, who happily started every week attacking some judge somewhere, making ethnic references and attacking a juror who was giving testimony at that moment in federal court. He doesn't know about the separation. This isn't political. This is judicial. And he kept that drumbeat up for quite a while. I also described a little bit something I'm going to talk to you about, and that is what happened in Northern Ireland. It may seem irrelevant, may seem extremely different, but I went 6 times to Northern Ireland, mostly during the Troubles, which lasted for 25 years. I investigated 3 separate murders. During that time of the Troubles, 12 judges were murdered. The hate, nobody in this country knows what the limits of the present hate will be. We don't know that. It is perhaps small, perhaps not so small. The FBI is working hard to monitor encrypted messages that you and I wouldn't see, but are very specific. Next point. What does terror sound like? What are we talking about? The doorbell rings. The judge's son says, I'll get it. Looks out the window, sees a delivery man. Says, it's a delivery man, probably, he said, opens the door and is shot and dies. That's what happened to a federal judge in New Jersey. Her husband was survived, as far as I know, I hope, but was terribly injured. Why is that? Because she's Hispanic. You think that we are encapsulated in our happy lives? Hopefully you're having a happy life. I hope you are. Away from all that. Northern Ireland taught me that it can all get out of control. The New York Times today has 2 articles about civil war in different contexts. After I wrote the 2 articles, and not connected in any way with the 2 articles, my wife and I, she was a judge for 40 years in the Superior Court in Alameda County, California. We received 5 emails over a period of about 3 weeks that threatened us with death. Me, because he said, I have no memory of this man because I turned him down as a client. I tell you that story to show you that I'm a person of good judgment. This is what upset him. As to my wife, he sat in her courtroom at some time. We don't know what the problem was. This is a man, and I want to tell you what happens in these cases, who was committed to Napa, which in California is for the criminally insane. And he was released. We have laws, which I'm very sympathetic about. I like the laws actually that try to allow people out when they can be out. But that's a human judgment. Let me tell you that we didn't get a lot of attention on our little problem. I made some calls. I have a voice that I can summon up as a senior partner, which makes it sound like you better do this. And they pretty much ignored that. So what are the precautions? And here we get to this tough question. Do we think that a judge who is threatened with death, as my wife was, or any judges, that gets these letters and these threats, do we think that has no effect on them? Do we understand what happens when someone is threatened like that? Listen to what the man said. Jim, he's talking to me, eat S and die, okay? I'm gonna pump you full of 12,000 rounds of alpha, cyber, or whatever. Call the pigs, go ahead. Prepare for hell, you, and he calls my wife a name. They attempted to kill me with extra lethal injections. Suddenly, we have this man in our life, and I start my mornings looking at the messages to see if there's another one, okay? Now, the process is inadequate. The second department of the government, that would be the legislature, has always been suspicious of judges. They seem to be overruling them and striking down things as unconstitutional and all that. They're a problem. And so their priorities don't meet the same as all the new security devices for the Capitol, which I certainly agree with, and for the Secret Service that protects the President of the United States. These judges, once they leave the courtroom, certainly, they're on their own. And the hate is mounting. It hasn't, like the virus, you can't say that in New York it's reached the peak. Nobody thinks it's reached the peak. And so in some ways, we're getting ready for that. I close
James,
with.
thank you so much. I didn't mean to interrupt. James,
Yeah.
we need to move on because we want to make sure we have enough time for questions.
Okay.
Thank you for sharing that.
One
Please,
last
yes.
point. Yeah, one last point. What happens to a person when they're threatened with death? This was explained to me by a security person. It goes back to the days when people were walking in the jungle all by themselves, they thought, and they hear a twig break. The body fills with sugar to enable you to fight the whatever it is that's coming after you, and the tension rises. Judges are not immune from that problem. So that's my thought on context, Richard. Thank you.
Thank you so much for sharing that and your personal story. Our conversation then has been pointing out that we have legislative attacks on the courts that are spreading throughout the country. We have attacks on the civility of counsel and the legitimacy of our ability to conduct proceedings that aren't that maintain that civility central to it, and that sometimes this civility bleeds over into actual violence, both in our own country and as we've seen in others. Erwin, perhaps you could help us by understanding the very real First Amendment implications that we have going on in this area.
Of course, it's truly an honor to be part of this great panel in this conference. I just wrote an op-ed piece about yesterday's Supreme Court decision. It says the Supreme Court's decision striking down a requirement for vaccination or testing in the workplace makes no sense as a matter of law or public health. The 6 Republican justices abandoned their commitment to textualism and ignored the plain language of the statute. They ignored the reality of pandemic that has killed over 850,000 in the United States, over 10 million in the world. Many more will needlessly get sick and die because of the Supreme Court's ruling. The only way to understand the court's decision is to see it as 6 conservative justices reflecting the misguided conservative denial about COVID and vaccines. Is that an improper attack on the judiciary? It's exactly what the 3 dissenting justices said yesterday. If I undermine judicial independence in some way, I believe that criticism of courts and of judges is speech protected by the First Amendment. It's a desirable, indeed a necessary part of the democratic process. Would I prefer that all discussion about courts and lawyers be civil? Yes. Would I prefer that it always be accurate? Yes. But I think it's very important to draw a distinction between speech that's protected by the First Amendment and actions or speech that's not protected by the First Amendment. I've learned a great deal from the 3 prior presentations, but I do think it's important to draw this distinction. So I want to make 2 points. The first is that criticism of courts, decisions, justices, and judges is protected by the First Amendment, and we shouldn't treat it as, quote, an attack on the judiciary. But second, actions taken against courts and judges, such as recalls, cuts in funding, threats against judges and their family, violence, that's not protected by the Constitution. And that really is a threat to judicial independence. So as to my first point, in New York Times versus Sullivan, the Supreme Court protects, quote, a profound national commitment to the principle the debate on public issues should be uninhibited, robust, and wide open, and that may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. This includes what can be said about judges and justices. In 1959, the Supreme Court handed down In re Sawyer. It's a case that involved a very famous labor lawyer, Harriet Buslag Sawyer, who was being disciplined and disbarred for her criticism of judges, and the Supreme Court ruled in her favor. Here in the United States Court of Appeals for the Ninth Circuit, the most important case was Yagman versus Standing Committee on Discipline. Stephen Yagman is a controversial civil rights lawyer in Los Angeles. He gave an interview with a reporter for the legal newspaper, The Daily Journal, in which he spoke of a particular judge and said, his rulings, especially sanctions, were anti-Semitic, that the judge was often drunk on the bench in the afternoons. It's a shame there weren't cameras in the courtroom so you could see the judge was a buffoon. the Standing Committee on Discipline in the Central District of California suspended Yagman for 2 years from practicing in federal courts. The Ninth Circuit reversed that, and the Ninth Circuit said speech about judges is protected by the First Amendment unless it meets the New York Times standard of actual malice. That is, unless it can be proven that the speech was false with reckless disregard of the truth. Subsequent to the Yagman case, the American Bar Association amended Model Rule 8.2 to specifically say that lawyers could be punished for their criticism of judges of courts only if it met this standard, only was shown there was actual malice, that the speaker knew the statement was false or acted with reckless disregard of the truth. This is the way that it should be. Judges are government officials. They should be no more immune from criticism than any other government officials. Indeed, the decisions of the Supreme Court, of lower courts, federal and state, affect all of us, often in the most important, the most intimate aspects of our lives. I would be a hypocrite to say anything else. If you look at the titles of some of my books, like The Conservative Assault on the Constitution, The Case Against the Supreme Court, or most recently, Presumed Guilty, How the Supreme Court has Empowered the Police and Subverted Civil Rights, you see that I try to practice what I'm talking about today. I didn't like when Donald Trump referred to a judge in Washington State as a so-called judge. I didn't like when he attacked a judge in Southern California on account of race, but it was speech that was protected by the First Amendment. I have heard some say that such criticism of courts and judges undermines legitimacy of the judiciary. But in a democracy, we never try to gain legitimacy for an institution by silencing critics. I cannot try as a dean of a law school to enhance my own legitimacy by silencing those who would want to criticize me, nor can we do that for judges or for courts. Besides, legitimacy that's gained by silence is a false legitimacy. It also assumes that this false legitimacy is more important than speech. Denyse made important points about the lack of civility within the legal profession. Been a lawyer for over 4 decades. I've seen in the briefs that are filed against me and in the briefs that I read, the lack of civility that she describes. I believe that is highly undesirable, and I strongly support efforts at civility. But I also think when we're talking about judges and courts, we're talking about government institutions, and they need to be subjected to criticism like any other government institution. But second, there is a threat to judicial independence when the attacks on judges and courts go beyond the verbal that's protected by the First Amendment. And here I think what Alicia was talking about was so important. And these are the attacks on the judiciary we should focus on. This is where what I think that Jim Brosnahan was talking about, so important and something that we need to focus on. Let me give some examples. Let me start with something that occurred in California just a couple of years ago, the recall of Aaron Persky. Judge Persky was hearing a sexual assault case. He issued a sentence that was within the recommendation of the probation department, but he was then targeted for a recall. So much that was said in the recall effort about him and his rulings was just false. He was attributed to handing down cases where he wasn't the judge at all. We saw that claims about the importance of judicial independence have little resonance with the voters. 60% of the voters decided to vote in favor of a recall of Judge Persky. By all accounts, Judge Persky was an excellent jurist. I fear that this attack on the judiciary will resonate with judges throughout the state. They know that if they hand down a sentence that's perceived as too lenient, they could be subjected to recall or defeat. But I've never heard of a judge being subjected to recall if the judge hands down a sentence that's too draconian. The threats to the budgets of state judiciaries is a threat to judicial independence. This is what Alicia was talking about. There are examples in addition to the one she mentioned. There's how when the Kansas Supreme Court required the funding of schools in the state, the Kansas legislature threatened to defund the Kansas judiciary. Or a successful instance when this occurred when the Alaska Supreme Court said that the Alaska Constitution required state funding through Medicaid of abortion, the governor of Alaska cut the Alaska Judiciary's budget by exactly that amount. That is a threat to judicial independence. What Jim spoke about is something we have to all listen to carefully. When judges, the family's physical safety is threatened, that's not speech protected by the First Amendment. The Supreme Court has long said that true threats are not constitutionally protected speech. We need to respond and respond clearly and forcefully to protect our judges. And then there are the acts of violence that have occurred against judges. I think here of Robert Vance, a judge on the United States Court of Appeals 11th Circuit, who was killed by a bomb. I think of Joan Lefkoe, whose husband and mother were killed when a disgruntled litigant came to where she was living. And there's been mention already of Esther Salas. It's the story that Jim was telling, a federal judge in New Jersey whose son was killed and whose husband was shot. We must do more to protect our judges from these threats. There has been a 400% increase in threats against judges in recent years. There's things we need to do. We need to dramatically increase the budget at the federal and state level, provide protection for judicial officers. Also, we must make sure that we can cleanse websites and social media of any identifying information, such as home addresses for judges, so as to do more to protect them. So what I've tried to say in my remarks is I think it's crucial to draw a distinction between attacks that are protected speech under the First Amendment, and they may make us uncomfortable, but that's what the First Amendment is about, in other types of attacks, and that's really where we should be focusing our attention.
Erwin, thank you so much for those fantastic comments. We have a few questions coming in from the audience, and all of them are really focusing in on this distinction between the legitimate type of attacks and conversation, Erwin, that you're discussing, and the way that it bleeds over perhaps into this hyper-partisanship, the way that it might be used for gamesmanship and ultimately towards violence. I'm wondering if you and any of you have this sort of way of articulating or thinking about where that line is drawn. Some of even the legislative approaches, Alicia, that you've spoken about, they've been directly designed at disempowering courts who have made decisions we don't like. Others have tried to correct or expand or democratize, in some sense, some of our courts. Where do we draw this very speech and violence? Perhaps that's an easier line. Response and almost punishment is a different line. How might we think about this?
Well, I agree with not only the words the dean just shared with us, but the sentiments of if we're a democracy, then there will be wild debate. There won't be, however, falsehood. And I noticed, for example, in the our firm represents some of these folks, so you can discount my reactions. But Congress doesn't seem to understand that a lot of what's on social media is protected by the First Amendment, and they're going to regulate it or something. They're going to do something, and I think the line is not just a legal line, but it's a governmental line. It kind of depends on who's talking. It is true that the president can say and did say all kinds of things, and that's his right under the First Amendment. I agree with that completely, and I have the right to vote. And I would like someone with the discretion to not attack people because they're of Spanish heritage and so forth. I would prefer someone who figures out a way to bring us all together. I just want to underline the fact, I think we're headed into a terrible time. And I don't think the judges are immune from the violence, which is not protected by anything.
I guess I'll jump in just to say, I think certainly the speech that Dean Chemerinsky was speaking to is protected speech under the First Amendment. And, I do criticize the Supreme Court all the time. And, I think it's not only appropriate, but healthy and a critical part of a healthy democracy. I do think that there are kinds of speech criticizing judges that, while protected under the First Amendment, it's appropriate to condemn and to try to, to the extent that we have, social norming to discourage that, and for there to be, kind of social consequences to sort of antisocial behavior. I mean, I'll say, we do a lot of work at the Brennan Center with in the States, and, just speaking with people that we work with on the ground anecdotally, some of these kind of very targeted personal attacks on judges' integrity in the context of criticizing opinions, whether they be right or wrong, or criticizing the court may be right or wrong, anecdotally, at least, very much, I think, has sometimes contributed to concerns about things like physical safety, and, more broadly have contributed to concerns about sort of what that might mean for kind of public confidence in the institution, things that we value. And so, I mean, I think all I would say is that I think that, there's the question of what do you try to bar or use the power of the state to limit. But then there's also the question of, what should we as the legal community or other interesting actors, condemn? And I think it can be important at times to speak out when people cross the line, and recognizing that where exactly that line is between appropriate criticism and inappropriate speech is a hard one. And, obviously itself subject to debate.
Are there appropriate reforms that don't constitute attacks? Some of the measures you were outlining at the beginning of our conversation seemed vindictive almost towards actors who had made decisions. Dean Chemerinsky mentioned some of these as well. Are there some reforms that would not constitute attacks, but that might fall more within the type of fair criticism and speech that we have been talking about that can be healthy for our democracy?
Absolutely. I think here too, the lines can be, the lines are not always clear. So I think the context matters. Something could be retaliatory in one context and, be a perfectly appropriate, court administration reform in another context. I think there is also, an appropriate back and forth between the courts and the political branches around, around judicial decision making. I mean, that I think might be a webinar in itself. But yes. I think with all of these things that I think the lines can be difficult to draw, but I think it's also important to call out when we see very kind of overt and extreme attacks on judicial independence.
I cannot thank you all enough for this fantastic panel. I would love to have this continue going on. Today's afternoon will continue going on. So Alicia, Denyse, James, Erwin, thank you so much. I'm going to turn it over to Mary Hoops now, who's from the Berkeley Judicial Institute, and will be moderating our second panel after just a short break. Thank you again, everybody.
Welcome back, everyone. Thank you so much for joining us here today. We're so excited to see such a large and engaged audience. My name is Mary Hoops. I'm the Director of Research at the Berkeley Judicial Institute, and I have the privilege of moderating the second panel. So for those of you that were here for the first, we talked a lot about the prevalence of attacks on the courts. And in the second panel, we'll start to consider the implications of these attacks for both the judiciary and for the legal profession for practitioners. We have a very esteemed group of panelists of law faculty and one sitting judge with us. And in the interest of saving at least the last 10 or 15 minutes for discussion, I won't go through lengthy introductions, but I do want to give you a sense of who we'll be hearing from today. So we'll begin with Professor Nora Engstrom of Stanford Law School, who will talk about a tension between, on the one hand, wanting some degree of productive criticism of the courts, and on the other hand, considering what are the ethical constraints on these kinds of criticisms. We'll then hear from Professor Leslie Levin of the University of Connecticut Law School, who will turn to the response from the bar. So which lawyer organizations have waged some kind of response to these kinds of attacks? What have they looked like? What have the motivations been of these responses? And what can we see going forward for what these responses might look like? We then have a rare opportunity to hear from a sitting judge the Honorable Reggie Walton of the District Court of the District of Columbia, who will offer a really unique perspective as someone who, as a sitting judge, is living through the kinds of attacks that we're talking about today. And last but not least, we will hear from Professor Beth Thornburg from the SMU Dedman School of Law, who will look at social media attacks in particular on courts and judges, and then close by thinking about what kinds of responses could the judiciary engage in if it wanted to have some kind of response to social media attacks in particular. So thank you all again for being here, and we'll begin with Professor Engstrom.
Great. Thank you, Mary, for that wonderful introduction. And it is such a treat to be here today. So we're all rightfully concerned about increasingly personal attacks on American judges. Here we see just a small flavor of these attacks. And in fact, according to the U.S. Marshal Service, which is tasked with protecting federal judges and court personnel, perhaps fueled by overheated rhetoric, judges are increasingly imperiled. In the service's 2020 budget, it noted quite chillingly that over the past 3 years, incidents, inappropriate communications, and threats rose steadily by more than 40%. And it went on to note that it expects these threats to increase rather than to dissipate. And now my task in my brief remarks today isn't to define the problem or discuss its roots or scope or severity. That's been done by the prior panel. Rather, my charge is to discuss the ethical architecture surrounding it, and surrounding in particular ad hominem attacks on judges, as we as a profession grapple with the appropriate response. So when we look at attacks on judges, some ethical rules are directly implicated. So these are rules 8.2a, which prohibits a lawyer from making false statements concerning a judge's qualifications or integrity, 8.4d, which prohibits a lawyer from engaging in conduct that is prejudicial to the administration of justice. And when I teach this, I always call just this the catch-all provision, and also 3.5d, which prohibits conduct intended to disrupt a tribunal. And these rules, in fact, have recently served as the basis for attorney discipline when lawyers' criticism of judges seemingly crossed the line. Meanwhile, other authority also indicates that lawyers' criticism of judges ought to be restrained, and lawyers more generally are supposed to urge respect for judicial processes. The preamble to the rules says as much, as does a comment 3 that accompanies Rule 8.2. So a fair reading of the rules suggests that lawyers should mostly keep their criticism of judges to a minimum, and when warranted, they're encouraged to speak up in judges' defense. So this isn't new. The canons and then the code, the rules predecessors, follow the same general script, noting lawyers' duty to support judges, or as a 1924 opinion put it, as the duty of an attorney to refrain from doing anything which will tend to destroy the confidence of the public in the courts or to bring the courts into disrepute. Yet it can't be that all judicial criticism should be stifled. And this was Dean Chemerinsky's point in the last panel. Sometimes criticism is healthy, even necessary. Sometimes judges do err, and some judges do frankly abuse the public's trust. And it is essential that their misdeeds be called out, particularly given the immense power that judges have and the near total immunity they enjoy as a result of sovereign governmental immunity doctrine. This too, the rules at least tentatively recognize. So the preamble to the rule advises that it is the lawyer's duty when necessary to challenge the rectitude of official action, and Rule 8.3 B, what I call the tattling provision, demands that lawyers report judges' misconduct when warranted. And just as there are plenty of notable voices calling for lawyers to muffle their criticism of judges, there are others who say that we must call out dishonest, predatory, or biased conduct wherever we see it. And it's that act of holding one another to account that will actually promote the nation's confidence in the country's laws. So while some courts say we got to at all counts do nothing to destroy the public confidence in the courts, others say, such as Chief Justice Harlan Fisk Stone, much like Dean Chemerinsky in the last panel, I have no patience with the complaint that criticism of judicial action involves any lack of respect for the courts. When courts deal, as ours do, with great public questions, the only protection against unwise decisions is careful scrutiny of their action and fearless comment upon it. So in that respect, then, modern attacks on the judiciary present a quandary. It is good to criticize. Sometimes it is important to criticize. And lawyers are uniquely positioned to comment on judicial lapses, essentially to act as the public's eyes and ears. But certain kinds of criticism is dangerous and arguably should be suppressed. It seems to fuel egregious attacks, imperil our judicial officers, and tarnish the public confidence in the courts. So it's a bit of a Goldilocks problem. We want some public criticism, not too little, not too much, definitely of the right flavor. And the ethical rules capture some of these tensions, but speak mostly in generalities, and so do little to help us navigate between these dueling demands. Beyond that, there are a couple of guideposts that might be helpful, but are admittedly underspecified and question begging. So lawyers should criticize, but ideally when justified and never for illegitimate or tactical purposes. And two, and this is something talked about in the last panel, there is a stark difference between legitimate criticism and threatening attack, and we shouldn't, in some desire to be even-handed, blur those discrete categories. Fair enough, but limited. Beyond that, what real guidance can we in the Academy supply? My co-panelists will no doubt further enrich our thinking, but I'll leave with just two tentative ideas informed by the tensions I've discussed. First, the ABA and other institutions ought to reiterate lawyers' obligation to speak up. This speaking up both entails calling out judicial misconduct when warranted per 8.3b, and it also entails speaking up in defense of judges when judges are unjustly attacked. When we see that judges are being maligned or disparaged or simply dragged through the mud for ideological or partisan purposes, ethical conduct may require speech rather than silence. And the comment that accompanies Rule 8.2 that encourages speech is pretty tepid as written. It perhaps should be beefed up. Second, there is a glass house quality to some of this. So Reuters, NBC News, and the Wall Street Journal have recently concluded blockbuster investigations and turned up, frankly, egregious ethical misconduct. Judges imprisoning folks for little or no reason, randomly demanding drug tests of courtroom spectators, sexually harassing court personnel, engaging in barroom brawls, deciding cases in which they have a clear financial interest, and presiding when drunk. Furthermore, it's becoming increasingly clear that our judicial disciplinary systems are marked by opacity rather than transparency, and they very rarely mete out meaningful penalties. A system that operates in the dark and allows misdeeds to fester is likely to undermine rather than to fortify public confidence in the judicial system, and frankly is not fair to the vast majority of the nation's judges who are extraordinary public servants, who play by the rules, and who fulfill their oaths with honor and integrity. Thank you.
Thank you so much, Professor Engstrom. That was fantastic. I loved the quote about how the only protection against an unwise decision is careful scrutiny, fearless scrutiny. I think the last slide was also a powerful reminder of exactly what you said, a reminder that some criticism is fundamental to our system. And having given us this framework for the ethical constraints on such criticism, we'll turn next to Professor Leslie Levin, who will talk about lawyer organizations and give us a sense of which organizations have responded, why and how they've done so, and what we might see in the future for these kinds of responses. Thank you.
Okay, thanks so much. I want to say first, I am honored to be participating in this panel with these great panelists. And I am going to talk a little bit about lawyer organizations defending the judiciary, and not so much what they should do, but talk about what they have done, which I think is a bit of a window into what we can expect. And what I'm going to be focusing on is the most recent responses by lawyer organizations, specifically to Donald Trump's statements attacking judges from the beginning of his candidacy in 2016 until the end of his presidency. So I want to start out just by noting that we take it for granted here that lawyers and lawyer organizations will defend judges. But lawyer organizations in some countries don't defend judges, and they actually work very much in opposition to the courts. And I'll return at the end of my remarks to why I think that lawyer organizations will sometimes defend judges. I want to note that most of the lawyer organizations that spoke out to support the judiciary during 2016 to 2020 were mostly the ABA and large local bar associations on the East Coast and the West Coast. Basically the New York City Bar, the Philadelphia Bar Association, the Boston Bar Association, and the Bar Association of San Francisco. These had a history of speaking out on issues anyway, and I think that that's what we continue to see during that period. By lawyer organizations, I mean both traditional bar associations and other groups that are composed of lawyers. And in my project, what I looked at was all kinds of lawyer organizations, from the ABA to specialty bars, affinity bars, local bars. And I want to start out just by saying there's limitations on the ability of lawyer organizations to speak out, to advocate. And I just want to point out two of the obvious ones. One is when they are heterogeneous. They have lawyers with different interests and sometimes very different views about how to proceed. And they risk losing members if they speak out, and they're very conscious of that. The other is that mandatory state bars in the 31 jurisdictions are also constrained in their ability to speak. And what I saw when I looked at this is they were extraordinarily restrained in their willingness to speak out to defend the judiciary. So there are four instances during the 2016 to 2020 when judges faced particular verbal attacks from judges. The first was when candidate Trump suggested that Judge Gonzalo Curiel, a federal judge in San Diego, as you know, was hearing lawsuits against Trump University. And the first comment was that he was extremely hostile to Donald Trump and that he was Hispanic. At that point, only the Hispanic National Bar Association spoke out. But later that same year, candidate Trump ramped up his comments. And at that point, the ABA issued a statement. Only one state bar association spoke out. It was the New York State Bar Association. The local bar associations, the large ones in California, spoke out. The LACBA spoke out, the Bar Association of San Francisco, the San Diego Bar Association. The only specialty bar associations that spoke out were the American Association for Justice and the International Academy for Lawyers, in other words, for trial lawyers, in other words, those that litigate in courts. And aside from the Hispanic National Bar Association, only one other affinity bar spoke out. So just moving forward, then in time, or I guess more recently, within 2 weeks of his presidency, if you'll recall, Donald Trump again attacked a judge. This time it was Washington District Court Judge James Robarts, who he called the so-called judge. The ABA again issued a statement. This was 2 weeks into his presidency, and usually a new president will get a pass or a bit of a pass, but there were 3 voluntary bar associations, state bar associations that spoke out. Only 1 mandatory bar association issued a statement. It was, interestingly, the Wisconsin State Bar. The Washington State Bar, where the judge was sitting, did not speak out. 2 of the largest California local bar associations spoke out, as did the Philadelphia Bar Association and the Boston Bar. Again, another litigating specialty bar, the American Board of Trial Advocates, spoke out. No affinity bars spoke out except for the Hispanic National Bar Association. And I just want to read to you a little bit about what the American Bar Association president said. Make no mistake, personal attacks on judges are attacks on our Constitution. Let us be clear, the independence of the judiciary is not up for negotiation. She continued, there are no so-called judges in America. There are simply judges, fair and impartial. We must keep it that way. And she concluded, we protect the rule of law. We defend the Constitution. We are lawyers. We took an oath and those are our values. We will never give in, never, 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 never. Her remarks were reportedly met by a standing ovation. She actually gave them to the House of Delegates because just coincidentally, it was meeting at the time that these events occurred. But there was very little coverage of this in the mainstream media. Then in November 2018, so we're moving forward again, President Trump attacked Judge John Tiger, who was a federal district court judge sitting in San Francisco. He had issued a TRO enjoining President Trump's new asylum policy. President Trump called the decision a disgrace and referred to him as an Obama judge. He said he also then attacked the Ninth Circuit. If you recall, at that point, Chief Justice Roberts made an unusual statement defending the judiciary, which again provoked more comments from President Trump. At that time, the ABA, the Bar Association of San Francisco, the New York City Bar Association responded, but fairly mildly. American College of Trial Lawyers also responded. Going forward again, then in February 2020, if you recall, President Trump attacked Amy Berman Jackson as she was presiding over the Roger Stone case. This was the case in the time at which the Department of Justice had also issued a second sentencing memo suggesting a lesser sentence would be appropriate in this case. This was after Donald Trump had tweeted about the sentence. The ABA responded with a statement. The only state bar association to do so was the New York State Bar Association again. The only local bar associations that did so this time were on the East Coast, the New York City Bar, the Boston Bar Association, the Philadelphia Bar Association. The specialty bars that spoke out were the National Association of U.S. Attorneys, the American College of Trial Lawyers, the Federal Bar Association, the National Association of Criminal Defense Lawyers, all specialty bars that had a special interest in the courts or in these issues. There were no affinity bars that spoke out except for the Lawyers Defending American Democracy, which was a new organization that had emerged in 2018 because it felt like lawyers were not doing enough to defend constitutional norms and values. So what seems to affect these bar organizations, these lawyer organizations when they speak out? Well, one, as I mentioned before, was the history of the organizations, where we see that for the last 40 years or more, some of these large local bar associations have done so, and so has the ABA. Other factors that I think affect it are the composition of the bar organization, how homogeneous or heterogeneous it is, the nature of their interests, the relationship to the state, and by that I mean the mandatory bars are feeling obviously constrained. I suspect also the internal characteristics of these lawyer organizations, their resources, their mechanisms for rapid response and reaching consensus among the members about what a statement might look like. Why do they do it? Well, part of it is norms and values. Part of it is because, as Nora was mentioning, the codes that govern lawyers talk about the need to defend the judiciary. The oath that lawyers take refer to the defense of the Constitution, because of bar organization statements about that being part of their mission. And then part of it is, frankly, self-interest. Lawyers have an interest in supporting the courts because the public's views of the administration of justice also affect the way lawyers are viewed. Also because, frankly, the judiciary, an independent judiciary, helps to protect the profession from too much legislative regulation. And so they have that interest there. So who is listening to these messages? Well, not Donald Trump, because if he'd heard them, I think he would have responded. And there's no evidence that he did respond. Other lawyers did hear them. I believe some judges heard them. But as to the public, I don't think the public heard much about these messages. They really got remarkably little media attention. With the exception of Lawyers Defending American Democracy, that organization must have a great PR person, because those their statements got a fair amount of coverage. 4 brief takeaways, and then I'll be done. One is that state bars, as we can see, feel the mandatory bars, and even the large, in the heterogeneous state bars, they obviously feel constrained and are not speaking out much on these issues. Apart from the ABA, only a few of the large local bar associations are doing so, that have this history of doing so. The specialty and affinity bar associations will only speak out when it directly goes to their own interests. And finally, if lawyer organizations really want their voices to be heard, they've got to figure out a better way of amplifying their voices and being sure that those messages make it to the public. And I'll just end there. Thanks.
Thank you so much, Professor Levin. That was so helpful. I think from my perspective, we've had these defining moments, like the moment of the so-called judge, and yet I hadn't really seen this put in a larger time frame like this, of these 4 critical moments. And then I think one of the most salient points was this notion that the public heard very little of the responses. And I think that could give us something to think about in the Q&A about the implications of that and how we might do better. Next, we're going to hear from the Honorable Reggie Walton, who is a district judge in the District of Columbia. As I mentioned before, it's such a rare opportunity to hear from someone who, as a sitting judge, is living through the attacks and the criticisms that we've talked about today. Judge Walton.
Thank you, and good afternoon. I welcome the opportunity to speak about this subject because, as you say, I, along with my colleagues, are living through the experience that we are discussing. And my concern is that what we are experiencing does have the potential to impact on the ability and the willingness of judges to carry out our constitutional and statutory obligations that we have as judges to promote and protect the rule of law. I don't disagree with Dean Chemerinsky regarding the fact that judges have to be thick-skinned. And we have to appreciate that when we make rulings, that sometimes they're going to be criticized, because in every case, someone wins and someone loses. And inevitably, there are going to be concerns by those who lose, whether they be justified or not, that they did not receive the quality of justice they believe they were entitled to. And there'll be those who follow them or support them who have that same perspective. So I'm not criticizing those who exercise their First Amendment right to be critical of the courts, because it is a part of our constitutional system of government in America that people have a right to be critical and be critical of judges. But we are dealing with a totally different situation now, and it's having a profound impact on the judiciary, and I know it's having a profound impact on the judiciary here in Washington, D.C., where we handle a large number of cases that are high profile in nature with political implications. And as a result of that, inevitably, there are going to be criticisms that come our way. But the criticisms have resulted not just in criticism, but also has resulted in us being threatened. I have been threatened a number of times I know my colleagues have been threatened a number of times. In fact, one of my colleagues I don't know if he's still wearing a bulletproof vest, but had been wearing a bulletproof vest for some period of time because of the threats that had been directed at him. I also know of one of my other colleagues who unfortunately someone had been able to acquire her home phone number and left threats to her on her phone at her home. And we, in my chambers, we've received a number of threats. I've had a number of high-profile cases involving the Mueller report and other issues. And when we make rulings in those types of cases, and that's especially true now in reference to the January 6, 2021 cases, we have over 700 of those cases, and more of them are coming every day. And in those cases, when you have individuals before you and you make statements about that event and how repulsive that event was and how undermining to our democracy that event was to our democracy, we get criticism, and not just criticism, but threats on our lives. And it's even more troubling that those threats are not just directed at us as judges, but it ends up sometimes being directed at our families. Unfortunately, the Marshal Service, which is overwhelmed by the number of threats that we're experiencing, they don't have the resources. Congress has not made the resources available to them to really do the job that I know they would like to do to try and provide the level of protection to judges. When we receive threats, they may investigate, they may not. It's not because they're indifferent, but it's because they don't have, unfortunately, the resources. I've had to be under watch several times because of cases I've handled, and it's not a good way to live. We don't have the luxury of a president and the confines of the White House and the other protections that presidents have. And as a result of that, we are obviously a lot more vulnerable. And I think that, politicians should be cautious about the criticism that they directed us. As a judge of color, not only have I been subjected to threats, but I also have been subjected to vile and racist comments in reference to me, designed, I think, to humiliate, to degrade, and to undermine my credibility as a judge. And I find it very troubling. And this is where I find it real difficult, because the criticism, for example, against Judge Curiel, criticizing him because of his ethnicity and suggesting that that had something to do with his rulings, is something that can inspire people to act out directly against us in a violent way. Race, for example, has always been a precursor for violence against people in America. And some of the threats I get and some of the comments I get of a racial nature are very concerning, because I know that that can inspire people to take action of a violent nature against the judge because of their ethnicity or because of their color. I don't know what we do to resolve this problem. As a society, we've become more contentious, we're more divided, and I think the inevitable reality is that it's probably only going to get worse. I just have to hope and pray that myself and other judges who stand in the position of supporting and promoting the rule of law don't have to suffer at the hands of individuals by way of our life or our well-being, or our families' life or well-being. But we're in a difficult time in America, and I hope it's a time that we can survive. I'm not sure that we can, but I hope we can. But I have a lot of confidence in my fellow judges who will do what they have an obligation to do to promote the rule of law, will not be kowtowed by the threats that we receive, and we will do our best to ensure that we uphold and promote the rule of law, which we all took an oath to do when we became judges. But, a couple examples, and I'll close with this, as to how profound the problem can be. And it can be in some way also enhanced by the media. I don't think that the media, at least most media, intentionally give false impressions about what judges have done, but sometimes it happens. I had a case when I served on the local superior court where a woman was viciously killed, and the media falsely reported that I had the authority to detain that individual who was on supervision to me on probation, and that I didn't. And as a result of that decision, this woman was viciously killed. Well, that was not true, because at the time, for the offense that this individual, or the violation of probation he was accused of, I did not have the authority as a judge to detain him. The government had to make a request for detention in order for me to detain that individual. And as a result of this vicious murder that took place, it received national media coverage. I ended up being threatened as a result of that. And that was on the part of the media engaging in either sloppy journalism. I don't believe it was intentional, but nonetheless, it did put me in harm's way. And I also know, again, that politicians can make statements that put us in harm's way. I presided over the Scooter Libby trial, and I imposed a prison sentence on Mr. Libby once he was convicted. And the President Bush at that time, criticized me for having given that sentence and said it was too harsh. And the reality is that the Bush administration at that time was advocating that the sentence that I gave be a mandatory minimum sentence, which was the prior guideline sentence. But after the Supreme Court had held that the guidelines were unconstitutional and the Bush administration wasn't happy with that decision, they were trying to get Congress to make the bottom guideline sentences mandatory minimum sentences. And that was the sentence I imposed. But nonetheless, the president said that my sentence was too harsh. And then ultimately, Mr. Libby was pardoned by President Trump. And again, he took aim at me, saying that Mr. Libby had been treated unfairly. That type of speech by politicians, I think, is inappropriate, and it misconstrues reality. And as a result of that, it can cause individuals to take aggressive actions against us, because I have received, in reference to those comments, threats and derogatory comments in reference to me. This is, as I say, a very important subject that we need to be concerned about, because I think when you seek to undermine the judiciary, it goes straight to undermining our democracy. And it's a concern I think all of us have to be concerned about, and that we have to come up with innovative ways to try and deal with the problem on the one hand, and on the other hand, not do anything to suppress the First Amendment rights that the American public has to be critical of all in America, including judges.
Thank you so much, Judge Walton. I would imagine that it's difficult to share these things, and I speak on behalf of all of the panelists and the audience members in thanking you so much for your candor. I think we heard a lot that was very sobering in terms of the direct effects that the statements by politicians or the media can have in the lives of judges. For me, what was perhaps the most sobering was just this thought that so much of this is being driven by larger societal forces becoming more contentious, and thinking about how do we begin to address it given those larger forces. We did hear one very concrete thing as we think about how to move forward, and that was this need for more resources for the Marshal Service. So that at least gave me hope that there's something concrete that we could focus efforts on. But thank you so much, and for highlighting how judges of color are facing an even added burden on top of everything else that we've talked about today. We'll hear last from Professor Thornburg, who will turn to a related subject of the social media attacks on the judiciary, and thinking about, for those judges that might wish to become engaged in some kind of response, what that could look like. Thank you so much.
Thanks so much. It is an honor to be here on this program with these other fabulous speakers. It's hard to go last, especially on a Friday afternoon, but I will try to be moderately to the point. What I want to talk about is what is happening on social media, and whether there is anything that judges and their allies might do to respond. Also wanted to shout out to Denyse Clancy. It's so fun to have another SMU person on the panel. She is one of our most fabulous graduates. So why are social media attacks so effective? Why do they work so well? One reason is that there are widespread public knowledge gaps about the courts and how they work. So, for example, a recent-ish poll found that only 26% of the US population can name all 3 branches of government. And 31% of them couldn't name any branches. A lot of misunderstanding of the role of courts. Fun fact, 12% thought that the Bill of Rights protects your right to own pets. The approval ratings of the courts tend, especially on the federal level, to track agreement with their most recent controversial opinion. Although the public's opinions about their own state courts do tend to be a little bit more positive. And so if there's a field that might be more fertile for responses, it might be in that area. The other thing I want to point out is that these recent very politicized attacks on courts are not at all new. For example, there has been a long-standing, since at least the 1980s, project by various business groups, especially the U.S. Chamber of Commerce, also the American Tort Reform Association, to sow distrust of courts, especially judges. And I think one group we haven't mentioned so much yet today, and that is juries. They also attack plaintiffs' lawyers. That's kind of where the attacks that Denyse was mentioning come from. And some of the attacks are on substantive law they don't like, or procedural rules they don't like, but some of them go after courts and judges and juries in a much more personalized way. They use scary language like litigation explosion, liability crisis, runaway juries. They call it an epidemic. And the ATRA series that they call the hellhole reports, judicial hellholes annual reports, tell misleading horror stories. And some of those are aimed specifically at what judges did. And they are almost invariably very misleading. So that's why they work. And then what happens is that social media, and particularly Twitter, amplify it. They run the gamut from disagreement with a particular ruling to more personal attacks on the judges to threats, and they kind of interact, and it's not always so easy to draw the line about what it is. And they can be particularly effective when done by other branches of government. And as has been said earlier, the former president was the poster boy for that. And it's also partly about what catches on Twitter, what goes viral. And other than, like funny cat videos, some of what makes a tweet or a series of tweets really catch on is they invoke outrage. They include a simplified statement of facts or opinion, and it doesn't matter if they're true or false or misleading. They're just pithy, and it's in an area that sort of invokes the polarization of the public, and so attacks on judges in particular cases are perfectly positioned to have a wide impact, and especially if the person doing the tweeting has a large Twitter following. So, what if judges wanted to try to fill that knowledge gap that the public has, or respond? As Dean Chemerinsky said, there's First Amendment protections to quite a bit of what they do, and as many of us have said, it's proper to criticize judges or the reasoning of opinions. But when they go too far, is it a level playing field? Do the judges and their allies also have an even-handed ability to respond? And I'm going to focus on the judges here, who, by the way, when I give a speech on this paper, always say, the bar associations should do it for us. We shouldn't have to be defending ourselves. A a little bit of a disclaimer. When I wrote the paper, I was somewhat more optimistic about the ability to reach people on Twitter who don't already agree with you. And I'm become more pessimistic about that. But let me put my Pollyanna hat on for a moment. The thing that the judges in particular have to be aware of if they want to use Twitter as a response is that there are judicial ethics rules that are going to limit what they do. Generally speaking, looking at the rules themselves, also vague, social media rules are the same as the general rules about extrajudicial speech and conduct. Although a number of jurisdictions have issued advisory opinions that address social media specifically. And I should say, if you're interested in this topic, read my paper, Twitter and the So-Called Judge, because it's actually quite intricate because every jurisdiction has their own rules and they're a little bit different. So on the one hand, the judicial ethics rules encourage judges to speak, write, lecture, teach, and participate in other activities concerning the law, the legal system, and the administration of justice. So there's not just permission, but encouragement to use, among other things, social media to help the public understand the court system and what's going on. General civics education is absolutely legit. And there are some judges who do a really good job of that. I'm kind of a fangirl of Chief Justice McCormick in Michigan, who uses it quite effectively to spotlight what the Michigan courts are doing. She also is posting her Wordle scores, but then everybody's doing that on Twitter right now. So the general permission, speak. But there are some limits. One relates to pending and impending cases. And again, this language is a little bit different from state to state, but basically it'll say something like a judge shall not make any public statement that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court, not just your own court, but any court. And so if the misinformation is about a pending case, there is always the danger that saying something about it might be thought to run afoul of that prohibition. And remember, judges do not want to have grievances filed against them for violating the ethics rules. So this is going to have a chilling effect even on things that might be legit. If a judge did decide to respond, note that it is absolutely allowed to explain court procedures, like I'm not allowed to let somebody out on bail for that offense, or someone could do that for the judge. But even there, you would want to be really careful to just explain it, not characterize it. And some jurisdictions actually have a specific rule that says you can respond directly or through a third party to allegations in the media or elsewhere concerning the judge's conduct in a matter. So you can do it, but you have to be really careful. Another issue that's not really quite as big a deal on Twitter as it is on Facebook is making sure that none of your activities on Twitter would constitute ex parte communications. Don't be exchanging direct messages with the lawyers in your case. Don't be doing other things that would show that's not just open and out there. The one that maybe makes the biggest impact more generally are the prohibitions on activities that would reflect adversely on the judge's impartiality, integrity, or independence. And as sort of subset of that, a number of jurisdictions have limits on political activity, which has a very fuzzy definition of what's political. It may not be purely partisan political. And some ethics committees seem to think that that means that the judge has to avoid discussion of any controversial issue or participating in any quasi-politicized entity. So, for example, there are state bar opinions that a judge could not take a leadership role in the ACLU or the Southern Poverty Law Center and not even donate to the National Organization for Women. So if they don't want you to participate, they may not want you to tweet support either. I think some of the most far-reaching ethics opinions, which are very skeptical of judges commenting on controversial issues, probably violate the judge's First Amendment rights. But again, nobody wants to be the poster child for I was allowed to say that. Those are the three main areas: avoiding things that might make it look like you are biased, no ex parte communications, and watch out for pending and impending cases. So in conclusion, is there anything, this is back to, I'm feeling kind of depressed these days. Do we just throw up our hands? So here's my non-despairing response. The people who have been attacking the courts have been doing it for a long time. It is part of a patient, well-funded, multi-year effort. And so the courts and their allies need to do the same, to think long-term. And it is to a large extent about civics education. So think about activities with schools, and civics tends to fall in the gap when everybody's worried about passing their required tests. Think about and support civics education. Educate the local media. Local media is more likely to be helpful than national media in this area. And a lot of times it's really young reporters. They may not be very well educated about courts. Some judges neutrally cultivate relationships with the reporters that cover the courts, not commenting on pending cases. Traditional outreach outside of social media, all of those local meetings of the local chamber of commerce or the PTA or whatever, and use social media. Use it well. The more followers you can get, the better. And there's lots of stuff to read about how to maximize followers. So my word to the judges is get out there and start educating. Thanks very much. I hope there's a little bit of time for people to ask questions.
Wonderful. Thank you so much, Professor Thornburg. I really recommend to all of you this article, Twitter and the so-called judge. I think I've heard so many judges talk about how they're in this fundamentally different era with social media, and yet I think this article really fills an important gap in trying to, first make an argument about why we ought to encourage this and under what conditions could judges begin to engage. This relates to one question I wanted to pose to any of the panelists about to what extent do you see this as a fundamentally different era right now, these attacks on the courts? Do you see them as sort of a continuation of what we've seen before? And I think some of you started to address this. Of course, things like social media are different. I think there could be the argument that things like the so-called judge put us in a fundamentally different era where one decision that doesn't comport with someone's desired outcome, sparks this entire attack on the system as a whole and on the independence of the judiciary. So I'm curious, to what extent do you see this as fundamentally different than what we've encountered before, and what kinds of implications could this have for how we move forward and how we respond?
I'll jump in to start if that's okay, which I think it's such a good question. This is exactly the question that was on my mind too. And especially Beth, I think the way you've traced this kind of continuity and discontinuity is so thought-provoking and important. And the other thing that I think it's interesting to look in time with lawyers, and this feels new to me, it feels ramped up. But then it's also others, other professionals. So in October, the New York Times issued a report about threats to public health officials. The fact that the Times has identified, I'm quoting, more than 500 top health officials who left their jobs in the past 19 months, in part because of abuse and threats. So I do think this feels ramped up and new vis-a-vis judges. Maybe also vis-a-vis lawyers, given, Denyse's really important remarks. But I also think, and also we're not that far from the 1-year anniversary of January 6th. It's not just our public health officials or our judges, it's also our elected representatives who had their lives imperiled. So I think it does feel to me special, and I'm wondering how much is gained by kind of, thinking about our silo, but also thinking beyond our silo to others with, jobs of responsibility.
I think, I forget which one of you mentioned that part of the reason that it becomes a little depressing is that it's actually all part of the bigger societal picture. And so I think maybe what is new is how extremely polarized the whole society is, and how we are getting our information from almost totally different sources, and that just ramps all of it up, and on the violence, and gives crazy people the impression that killing a judge is just the right thing. Didn't Marjorie Taylor Greene just yesterday suggest Second Amendment related activities against the Democrats? So yes, I think it is both continuing and new.
I definitely think it's new. I've been a judge for about 39 years. I've never seen it like this. Throughout my career, I've been subject to threats, but never to the extent that we're experiencing now. And I agree, it's because our entire society has become so polarized. And a lot of these, high-profile political cases are appearing in court. And whenever we make a ruling in those cases, there's going to be a segment of society who's going to disagree with those decisions. And because we've become so polarized and society's become so hostile, it culminates in threats being made against the decision maker, which all too often are judges.
Thank you so much. I know we only have 2 minutes left. I guess a lot of the questions in the Q&A went to this question of to what extent are courts now, especially the Supreme Court, being perceived as very partisan, and how do we move forward from that? I guess the last question I'll pose, because I can't resist, because it's a Friday afternoon and I want to end on a slightly hopeful note. Is there anything that gives you optimism, given that climate, given this larger connection that we just talked about to the other professions? Is there anything that gives any of the panelists optimism as we move forward?
So I love the fact that lawyers got together and formed this Lawyers Defending American Democracy. And it's been quite vocal, and it's done more than just speak out. It's also filed complaints. It's done other things. So I love the fact that some lawyers are trying to address what they see are problems in terms of what's going on, at least in segments of society. So that's my Friday afternoon optimism.
I hate to leave on a down note, but I'm not optimistic. I am not. I think it's only going to get worse. And until we see society as a whole improve as far as the way we treat each other, I just think it's going to spiral downward. I hate to feel that way. I guess the optimism I have is the fact that despite what we see taking place, I think by and large, the judiciary has stood up and played out, the role that we've been given, despite the environment in which we exist.
I'll give a happy thought to the next generation of lawyers. I will say that the people in law school right now are largely there because they want to serve justice. They're public interest oriented, even if their career path is corporate and tax. So maybe the fact that the judges are continuing and the lawyers will continue to be concerned about justice is at least some reason for hope on a Friday afternoon.
Yeah, I can't improve upon that, so I'll just second what's been said.
Well, thank you all so much to the panelists and for the audience for being here. We are so grateful. And I did want to just highlight before we close that we'll continue this conversation in a lot of ways. If you just mark your calendars for May 26th, democracy's last line of defense, we will be able to pick up on some of these themes. But thank you all so much. We're really grateful for this tremendous conversation.